Bismillahirrahmanirrahim. Thank you for joining us across various time zones and a very warm welcome to another edition of Ginan Insights, a webinar series dedicated to deepening our understanding of the remarkable poetic heritage of Ginans. I'm Meera Mawani, and I'm delighted to have you joining us today for what promises to be a truly thought-provoking session. Ginan Insights webinar series was developed to explore different facets of the Ginan Granth literature through past and current areas of research in order to create greater awareness and space for sharing knowledge. One of the things we try to do in this series is look at Ginans not only as texts to be recited and cherished in developing our understanding, but as living documents that exist within wider historical, cultural, and political contexts. And today's session takes us into a dimension of that context, and that is the impact of colonial governance on Ismaili Khojas in the mid-19th century. To explore this question, I'm honored to welcome Dr. Amrita Shodhan as our guest speaker. Dr. Shodhan is a senior research fellow in the Department of History at SOAS, University of London. She holds a PhD from University of Chicago, and her doctoral research examined the legal representation of Khoja and Pushti Marga Vaishnava communities in the mid-19th century Bombay. Her work has been published as a book, A Question of Community, Religious Groups and Colonial Law, which is really essential reading for anyone who wants to understand how colonial legal frameworks reshaped the way religious communities in India were defined, governed, and understood. Dr. Shodhan has also worked on the history of Gujarat, gender, and modernity. Her other publications include, in 2023, an article, The Communal Question and Partition in British India and Palestine, in the edited volume, The Breakup of India and Palestine. This is a two-part webinar series on the impact of colonial governance on Ismaili Khojas and Ginans. In part one, Dr. Shodhan will talk us through the different colonial frameworks between 1847 and 1866 and their impact on the way in which colonial legal governance dealt with jamaats and religious authorities. Her presentation will address the differences in judgment between the 1847-1851 Khoja cases on property and inheritance and the 1866 Great Aga Khan case. The two periods represent a great divergence in the way that local communities were dealt with. In the first instance, the community was considered to be self-governing, and castes and jamaats were allowed to settle disputes through customary law. But by 1866, with the famous Aga Khan case, the court used its own understanding of Islam to rule on Khoja governance and identity. That shift from community self-governance to externally imposed religious definition and its consequences will be the center of today's talk. So with that context in mind, please join me in welcoming Dr. Amrita Shodhan. Over to you, Amrita.
Thank you very much, Yali Madad, everyone. It's really my pleasure to be here. Thank you, Meera, for inviting me, and Professor Shiraz Saab and everybody else from the Ginan Association. So I'm really pleased to be speaking today. It is, as Meera mentioned, thank you for that kind and good introduction. It really is, I'm going back to my dissertation, which was done a long time ago. But I'm glad to hear that people are still interested in it. So I'd like to present those ideas and the shift actually, and it's the shift in colonial governance that I'm examining. So I'm not seeing a pre-colonial presence of what was happening to the Satpanthi or Ismaili community. I'm starting with the colonial period itself. So transformation within the law in the colonial times that we are going to look at. But before I go into the main, I'll just give you an outline of what I'm going to say. As we said, how did colonialism affect Khoja religious authority in Bombay? That's the main question I'm trying to address. And we look at of course, colonialism was a very broad thing. It affected us in India in many different ways, economically, socially, politically, of course, in the first instance. But besides all those impacts, there was a legal transformation that happened in India where disputes were settled by the British colonial authorities. So, and the impact of this dispute resolution is what actually, so there was not a direct, it was not that the British colonial authorities directly said how religion should change, but there was an indirect impact of the colonial law and how it settled disputes. When it settled disputes, it made decisions on what were the religious or communal activities and communal practices. So that's what we are going to look at, how focusing on the legal and judicial processes and how that impacted the religious understandings and definitions. Religious authority was very much a legal authority in pre-colonial times. So when that authority changes, there's a change in religious practice as well. So in the beginning, I'll just give you a little background on who were the Khojas in the 1800s, um, what were the legal structures and how they functioned at the start of the 19th century. So I was saying the legal structures, I'll talk about them in the early 19th century, and then how some cases, I'll give examples of cases of dispute within the Khoja community and how they were solved in the 1840s in Bombay. Then perhaps many people know that in 1857 there was a major revolt against the British in India, and it led to the decline of the East India Company. So the early legal structures were under the East India Company, and after the 1857 rebellion, the company was disbanded, and the Queen Victoria became the Empress of India. Well, at that time, Queen of India and then Empress, and they changed all the legal structure as well, the structure of courts as well as some of the laws. So the way in which they dealt with Indians also was changed because there was a huge fear, and I'll talk about that. And then in the last section today, I will talk about the impact of this change with the new systems in the 1860s and how that impacted when the Aga Khan case came to court, when there was a dispute within the community on the use of community property. And the next part, next month, we will talk about more of the direct impact on Ginans themselves, but also on the religious literature. And there we will talk a little bit more in the second part about the shared heritage of the pre-colonial period and the transformation in the colonial with the impact of these kind of definitions of what is Muslim, what is Hindu, etc. So I'll set up the definition of Hindu and Muslim today, and then next week we'll see the next part we will look at the impact of that. So to just give some background of the 1840s in Bombay, it was a new town. There was still, in that picture, you can see Church Gate, which is still existed. It was a small walled city, and that's a main street going. We are looking at from inside the fort, out exiting the fort. At that time, many new migrants were coming into Bombay to take part in the trade and prosperity that was the result of British trade, of course, and many merchants from Kutch, Kathiawar, and Gujarat were coming in. Along with them were the Khojas. So there were the Khojas were approximately 1.8% of the population from 1840s to 1871, 1900 as well. They remain approximately 1.4 to 2% of the total population of Bombay. And that's very similar to the percentages of Memons, of Boras, of Bhatias, Lohanas. So the various different trading groups that came from Gujarat. So they were a small number. So beginning with 2,000 people in the 1840s to across 11,000 in 1901. But in terms of proportions, the numbers don't change. And they were, of course, becoming very prosperous with the trade in cotton, in indigo, in cloth to East Africa, as well as opium to China. This is the period of the opium trade as well. And some of this trade-related wealth, they were beginning to invest in the textile mill industry. So by 1851, when the first mill is established, textile mill, the Khoja Habib Ibrahim, 59, sorry. Habib Ibrahim was a shareholder in the first mill, that was Dawar's mill. And then Dharamsi Punjabai by 1870 owned 6 mills, when total number of mills at the time in Bombay were only 18. So they were really an important industrial community by the middle of the century, exactly the time in which the cases that we are studying. So, and that's just an image of some of the Khoja people. The picture of the Khoja lady is from 1870s, a little bit later. Yeah, about the same time. And that's an image from 1855. So you see the clothes and dress is very similar. And there is a lot of discussion about these clothing styles, of dressing styles, of the language that they speak at the time, along with other middle trading groups and middle castes and classes. The Khojas were also modernizing. They were achieving education. Many of them studied with tutors at home rather than going to school in the beginning. But they all learn to speak English and participate in the British sphere, British elite sphere. So there's a lot of discussion on the clothes as well, and they say that Khoja women are wearing too much jewelry, kadas, vitas, all these should be reduced. So by the end of the century, there is a much more modern, if you like, look, or westernized look. That's similar to the Parsis, for example, and other trading groups of the time. Sorry. At that time, and let me then describe the structure of the Bombay judiciary. This is still the East India Company rule, and there was a Supreme Court in Bombay that was established. So Bombay was, of course, British territory, East India Company territory from late 17th century. So that's through the 1680s to 1700s, there was a recorder's court, and then the Supreme Court is. Then the British, of course, conquer and defeat the Peshwa in Pune and the Marathas. So it's only from 1818 onwards that a lot of the hinterland of Bombay, parts of Ahmedabad as well, parts of Gujarat and Kathiawar, but a lot of the princely states continue in Kathiawar and Kutch because it was a princely state. Baroda was a princely state. But they were all defeated and they were reinstated as princes around 1818 when the Marathas were defeated. And it's from 1818 that Bombay Presidency, roughly as we know it, Gujarat and Bombay states today, was formed between 1818 and after the conquest in 1818. By 1823, they have the administrative structure in place. And of course, the governor of Bombay at the time was Elphinstone, Mount Stuart Elphinstone, who you may have heard of. There were, under the Supreme Court that was established in Bombay then, there was the civil court and the criminal courts in district towns like Surat and Ahmedabad. And under these, Sadar Diwani and Nizami Adalats, there were a variety of different authorities that were recognized by the British. So the Qazis, the castes, the Jamaats, the Panchayats, they were allowed to solve the legal problems of their members. And and if they didn't agree with their local panchayat solution or Jamaat solution, they could go to the higher court. And sometimes some of these cases went directly to the Sadr courts if they were of higher value, or if so there were different kind of rules about which courts could go in appeal and which could go as a direct case to these Sadr, Diwani and Nizami Adalats. The rule of decision in these lower courts and even in the Supreme Court at the time was the rule of the defendant, whatever the people believed in, because there was no constitution or no legal order or charter, no legal code that these British courts, so the Sadr Adalats, the Diwani Adalats, they were all British courts, but they were run like they were descendants of the Mughal courts. For example, Surat was a Nawabi, Mughal Nawabi, and the British takeover, Jonathan Duncan was the governor first, and then Elphinstone after that. And so the British ruled over the disputes, but they used the local advice of the Qazis. They had Muslim legal officers and Hindu legal officers to advise the judge of the law. And we look at that in its effect actually in the next discussion. So the traditional authorities were admitted in the court to give the rule of decision. How should we decide whether so-and-so had done something wrong? Or what was the inheritance right? What rule should be used to determine the inheritance, for example? So many of these traditional authorities included castes. So they recognized, and they would call the whole caste to come to court to give the decision, for example. Or they assembled, caste or caste authorities, 3 or 4 members, or caste heads. Or, of course, they did accept religious texts as well. And the primary decision was based on customary practice. The judge said during, I'm going to read out some of the legal cases. For example, in 1811, in a suit, there was a decision to be made about how caste feasts should be held and who should be invited. And the court determined the rule to be followed by calling up the whole of the caste and taking the vote of every individual member upon the question in court. Similarly, in the case of the Dasha Ismaili Banyas, 250 members were called to decide whether Raliat, she was the widow of the caste priest, and whether she could continue her husband's role as the caste priest. The court determined her right to be the caste priest in accordance with the custom of the country, because the Shastra didn't mention that a woman could inherit, but they said the people who came to court, her caste members, said that that was allowed, and therefore the court agreed that that was the rule to be applied in the case. In another succession dispute among Konkani Muslims, the law of the Quran was set aside for customary practice of inheritance, where natural sons received maintenance from the income from the watan rather than a share of the income. So they only got maintenance, but the Quranic practice was to get a share of the inheritance. So that the Quranic precedence was not taken, but local practice was consulted. And Justice Perry, who was one of the judges of the Supreme Court, quoted the application of custom in inheritance and succession as a regular practice. So custom was the one that determined inheritance. In the cases, I'm going to examine them in detail now. There was another case in Surat where the practice of selling waqf property was being discussed. And they said, yes, waqf property can be sold, even though the Shariat practice suggested that property of the nature of waqf cannot be sold. But they argued on the basis of local custom that waqf property could be sold. So in this way, there were many cases that were determined by calling the people to court to solve their problems. So there was no single law that was applied from either religious text or British law. And Thomas Erskine Perry, whose image is very faint, I don't know if you can see it, it's in the National Portrait Gallery now. He was one of the judges in the Supreme Court for a long time, and he's written a report of the cases he judged there. That's a title page of the reports. And the case I want to discuss is the Khoja inheritance case in 1847. It was case of Hirbai and others versus Sonbai. Hirbai is the daughter and Sonbai was the mother. And the daughters, and remember 1847, the Aga Khan was still in Calcutta, but he had already visited Bombay after coming from the first Aga Khan, Hassan Ali Shah Sahib. And he had come to Bombay, he had worked with the British in Sindh as already, and he was in Calcutta for a while, but he was in touch with many of them. So he supported the daughters and said that Shariat or Quranic practice suggests that daughters can inherit in the father's property. But Sonbai, the wife, sued that these daughters are married and they don't take any share by custom. And in our families or in our community, daughters do not inherit. And so then when the case, the judge ruled in favor of the wife, and he said this was customary practice, and that custom was the determinant in English law. And I want to take you through some of the arguments that he presented, because he gave a very long judgment. And he said the importance of recognizing custom was, of course, the custom had to be reasonable. So if there was a bad custom, we won't recognize it. And so he asked the question, was disinheriting daughters reasonable? And Justice Perry said that a custom for females to take no share in the inheritance is not unreasonable in the eyes of English law. Therefore, Khoja inheritance practice, we can accept the Khoja practice, custom, that daughters do not inherit, and we can apply that. So there was no question of looking at the textual or Shariat rules. And this practice of allowing daughters to be disinherited then continued in India till 1937, when the Shariat Act was passed. But even in the Shariat Act, agricultural properties of Khojas and Memons are an exception, and they do not have to be divided according to Shariat inheritance laws. The judge also asks, should Shariat be used? And he says, Mohammedans, that was the word they use for Muslims, their inheritance and succession by legal practice, by the code that Elphinstone had instituted. In the code, he said, in the case of Hindus, they have to use customs of the caste, but in the case of Mohammedans, inheritance and succession shall be determined by the laws and usages of the Muslims. But he says it was believed erroneously. So that was the legal code, that Muslims should use Muslim law. But the Judge Perry says that actually, when they made that law, it was erroneously believed that all of the population of India could be divided between two groups, Muslim and Hindu. They used the word Mohammedan and Gentoo at the time, Gentoo for Gentiles, or not people of the book. And he said, actually, in practice, there were so many sects and so many groups that there is no great division between Muslims and Gentoo. So the policy actually depended broadly on the recognizable basis of allowing the newly conquered people to retain their domestic usages. That's what they meant, he said. So he's interpreting the law and saying they are just using short form of Mohammedan and Gentoo for all the different groups, and they wanted the local laws of these groups to apply. So he did consider the question of Shariat or Mohammedan law, and he said actually it doesn't apply. The rule is only for recognizing custom or domestic usage, that's custom. So there, and of course, he does not make any attempt to determine the origin of the Khojas at the time. Who were the Khojas? What should they be practicing in their inheritance laws? He doesn't ask those questions. And in fact, he says that their language is Kutchi, their religion is Mohammedan, their dress, appearance, and manners, for the most part, Hindu. But these latter facts, their dress and manners and custom, do not warrant the conclusion that the Khojas were originally Hindu. He says, such is the influence of Hindu manners and opinions on all castes and colors who come in connection with the Hindus, that they all become like Hindus. So he assumed, in fact, at the time, that the Khojas had migrated to India from the Middle East, from Iran, and they had taken on Hindu characters after coming to India. So he's not only referring to the Pirs, he's referring to all the Khojas. And he says, often it is like the black soil of Deccan, which has the property of converting foreign substances into their own material. So he's using his Orientalist understanding of the power of India and power of local practice in India to interpret what the Khojas believed. So there was another case also at the time. It came before the same judge. That was the Great Khoja case. It was a Khoja case, not the Aga Khan case, that's later. But the Great Khoja case came up for possession of Jamaat Khana and properties. So the Aga Khan moved from Calcutta to Bombay in 1848, and he soon sets up his household there. And as he's setting up his authority with the local Jamaats, the local Jamaat, you realize, we discussed how important and rich they have becoming. They are coming into more and more wealth. So they were clashing with, and they were also transforming in terms of their behavior. They were asking for reform, new schools, different kinds of behavior for the women as well. And in those changes, they felt that they were in conflict with the Aga Khan's practices. And it was the Aga Khan who padlocked the Jamaat Khana in Bombay at the time, where the Khoja Sheths, Sheth is the Gujarati word for merchant princes or powerful merchants. So they owned the property in their names in the collector's office and other places. So they felt they had the right to these properties, but the Aga Khan had padlocked them. So there was a case of trespass, and the Judge Perry called the Jamaat to the court, similar to what other courts had been doing at the time. And he declared what he called a Bill of Rights for the Jamaat. He said all members of the Jamaat should meet together and they should elect their officers, manage their affairs, and decide who gets the power to use the premises. And then again, so that case was settled. Again, a second case within 3 years again came to the court. And this time he called the caste or the Jamaat before the court. And I should say the word caste and Jamaat, Naat in Gujarati or Nyati, and Jamaat are, in Gujarati, they are the same word. In the 1840s, they used interchangeably, Naat and Jamaat. And even the dictionary says Naat is Jamaat and Jamaat is Naat. So there is no Hindu-Muslim connotation to the use of the word caste and Jamaat. So Jamaat, there was a Brahmin Jamaat, Sonar Jamaat, as well as the Khoja Jamaat or the Memon Jamaat. So the word Jamaat was not used just for Muslims, and the word Nath was also not used just for Hindus. But today we say Nath is Hindu and Jamaat is the Muslim community. So he called the Jamaat in 1851 before the court and said, make a majority decision according to which the Jamaat Khana should be used. He even appointed a legal firm that would help the arbitration. But he didn't draw up a binding decision. He didn't make the judgment. He didn't write the judgment up. And that's a flaw that comes up then in 1866 later. But the decision he organized or enabled a majority decision in the Jamaat, that lasted from 1851 to 1861. And again, he makes no attempt to determine who is the original religious belief that must use the property. The property is not based on what you believe. The property is based on how you are members of the Jamaat. You've paid your dues and you've contributed to the making of the property. And there is no question of authenticity of religious origins. It was just based on customary practices according to the memory of the group at the time. And this was not just for Khojas, it was the same practice as I showed before for all different caste and community. So 1857 is the big rebellion against the British. It starts in North India. There's an attempt, the British troops themselves, it starts with the troops that revolt against their officers, and then it moves to the different principalities and different smaller states like Tatya Tope. There was the Maratha kingdoms in the north, Gwalior and Jhansi, etc. There's really famous ones. But across North India, these smaller princes also joined the rebellion to throw the British out of India. There was an attempt that they would re-establish, though the Mughal prince was still Bahadur Shah, he was still the ruler of India. He was still the Mughal ruler, and East India Company had devolved power from this Mughal ruler, but they felt that he was just a puppet, so they were going to institute a new Mughal authority in Delhi to displace the British authority. That rebellion lasted for more than 8 months. There was huge massacres of many British people, women, as well as it had lots of repercussions even at home in England, where they heard about the news, and there were plays written about it, and lots of paintings as well that about how these sepoys or the local soldiers are mutinying. And mutiny is another word. Rebellion is the more common word used by Indians. And that created a sense of fear that the reason why this mutiny apparently started was the rumor that the bullets of these rifles were greased by cow and pig fat. So the cow fat would upset the religious sensibilities of the Hindus, and the pig fat would upset the religious sensibility of the Muslims. So that created a sense amongst the British that it's the religious faith or practice that was abused by this bullet, and that caused the rebellion. That was the common sense understanding of many British people and in the British government as well. So when Queen Victoria in 1858 dissolves the East India Company, she takes over power, the parliament takes over power over the government of India, and they become the government of India. And that's a picture of Queen Victoria in 1859. So she must have looked something like that at the time. She apparently took a great interest in the making of this declaration. And in her declaration, she said that people will, I thought I had an image of the declaration, but she promises no interference in religious practice and that all people will continue in their religious practices without interference. And that makes a big impact, I think, on the way in which local population is seen. As you saw in the Judge Perry's decisions, he said even though the people are supposed to be Mohammedan and Hindu, actually it is not, there are no two such large religious groups. There are many groups, subgroups or small communities who determine their law. Now the new dispensation is going to be all about religious law and the importance of religious law. And that makes a difference to our case as we study it. The system is also reorganized. There was, at that time, you saw Supreme Court in Bombay, and there was a Supreme Court in Calcutta and Madras as well, which is now Chennai. But now the Supreme Courts were independent of each other, and they didn't have to conform to, so the Bombay administration didn't have to conform to the Calcutta administration at the till 1858. Now in 1858, they set up 3 high courts in the 3 presidencies, and these high courts then report to the Privy Council, which was under the Queen. And so there was a uniform, all the 3 courts can use precedents from each other, and they have to conform to the same legal dispensation. So there is a uniform judicial, that's the judiciary, but there is also a uniform legal administration. And I want to just describe a few of the changes. So between 1850, and some of the legal change had started earlier. There was a legal council set up in 1837 with Macaulay, and then Henry Maine was a member of this advisory Governor General's Legislative Council. And they codified almost 261 new codes of evidence of all different kinds of codes. So new legal codes of evidence of administering law, different laws were set up. It was still not a constitution like we have today, but it was unwritten law, and it was using British legal systems, which was British common law systems, which based on precedents and discussion of the court at the time. However, yeah, that's so the new 260 new legal statutes that were uniformly to be used. So if there was an inheritance statute, it would have to apply equally across the country. So protection of the religion, that's the wording from the 1858 Act. We disclaim the right to impose our convictions on any of our subjects. We do strictly charge and enjoin all those who are in authority under us, so that's the Queen speaking, those in authority in India, they abstain from all interference with religious belief and worship, and that will offer any of our subjects. So that was seen as a freedom charter for the Indians, and the Indians really appreciated it. But in that process, in the new dispensation, legal and judicial dispensation, the court cases that the Khojas had to go through are quite differently dealt with. And I'll just examine some of that now. Just take a little. So the Aga Khan case is judged in 1866, and that's just an image from Nuru Mobin, if anybody knows the book. These were the Mukhi and Kamaria of the Bombay Jamaat at the time. Mukhi Ala Rakhya Sumar and Khaki Padamsi. And the issue of during the case was the same as the 1851 case. So the issue at the time was, as I said, 1851, the same as the 1851 use of the Jamaat Khana, the graveyard, and a lot of other collective property, the burial grounds as well. They wanted the people the people on the other side. So there were two sides. Where did it go? Sorry. Daya Mohammad, Habib Ibrahim, and others. They were 12, perhaps. So many people think that the word Barbhaya comes from the 12 people who complained about the use of the property by the Aga Khan, or restraints on the property by the Aga Khan and others. Um, uh, they were on the one side, and they were asking that the Aga Khan be restrained from interfering in the community. They should not be excommunicating, and they should allow the use of property to all the members of the Jamaat, whether they accept the Aga Khan as their leader or not. So that all the Khojas, regardless of their beliefs, but they didn't say that. They said all the Khojas were actually originally Sunni, and therefore Aga Khan should not be asked to interfere. And I'm going to talk a little bit about this difference in the way in which the 1860, so the case was filed in 1862, and when they filed the case, they said this is actually a continuation of our 1851 dispute, but now the case has become more serious. In 1861, actually, you may know from other writings that the Aga Khan himself asked for a declaration of faith, and he circulated a book in which members had to sign saying they were followers of the Aga Khan. And there were many small disputes between 51 and 61. We'll talk more about it also next time, because one of the big disputes was the use of the sarangi in the singing of the Ginan, and the kind of ritual that was to be used during the Jamaat Khana practices. The Aga Khan had a different type of practice. His mother was the Shah Fateh Ali Shah's daughter, and she used matam during Moram. That was something that the traditional Khoja practice in Bombay did not practice. So there were disputes like religious issues. The mosque that was in Bombay, it was established in 1822 by the Khoja Sheikhs, and they established a Sunni mosque. They also were starting a new school, and I think, yeah, so I'm sorry, I thought I had a slide about the reform activity that the Khojas were involved in. So the Sheikhs had a Sunni mosque. They started a new school with teaching in English, and their clothes I already talked about. They also did not want to they were associated with the Bhatiyas and the Kapols and other trading castes, Hindu castes, because they were all elite. Some of them were in partnership together in businesses with the Parsis as well. So they felt, and many of these Hindu trading castes were trying to break caste bonds as well. There was a group called the Paramhans Mandali, which said we should eat with each other, we should not have food restrictions. So there was there was an attempt to look to degrade caste, or at least talk about breaking caste bonds. So many of these Khojas also felt that they should think of themselves as part of the larger community, and they chose the elite Khojas. At least some of them chose the Sunni community rather, which was the elite community of Bombay at the time. Some of the Nawabs were Sunni, etc. So they are identifying in a different way with a different this So there is no doubt that they never thought of themselves as Hindus. Some people have argued that the Khojas were not sure whether they were Hindu or Muslim. In all the legal material I've read, there has been no doubt about that. They never present as Hindus who are, they know always that they were Muslim from the start, from their origin of the community. And that what kind of Muslim was the question. And so their attempt is to say that they were Sunnis. And that's the complaint they make in the court, that we were Sunnis in the origin, and therefore we should not be forced to pay dues to the Aga Khan or share our collections with the Aga Khan and support his expenditures. And the judgment in the case went for the Aga Khan. The judgment was read by Chief Justice Arnold. He was also the one, we'll talk about him. He was a very active and academic Chief Justice. So he tried to give different reasons for whatever judgment he passed. And he gave a very erudite judgment, which looked at the origins of the Khojas. And he said, in order to enjoy the full privilege of membership in the Khoja community, a person must be one of that sect whose ancestors were originally Hindus, which was converted to or throughout abided in the faith of the Shia Imami Ismailis, and which has always been and still is bound by ties of allegiance to the hereditary Imams of the Ismailis. So it's in this judgment that we find this direct link made from Hindus to conversion to the Ismaili faith. And it does not discuss the question of Jamaats or community governance or rule by practice or customary practice. It goes by what is the original faith. And how did they come to this discussion? How did he come to this judgment? As I said in the previous, I've already discussed this slide a little bit. In 1866, whereas in 1851, the right to use property was based on custom and majority opinion of the group, in 1866, the court says property is an unmarked shared possession, and only those should use it who have the correct belief. The property is viewed as a charitable trust, where rights of the litigants will be regulated by reference to the religious tenets held by the community in its origins. So even a minority holding those original beliefs will prevail against a majority which has receded from them. So whereas in 1850s, we saw majority decision and community practice was established, in 1866, the court is going so far as to say it's not a question of majority and minority, it's a question of correct belief. So it's a very different mindset that the court brings to the case. And then how did the court identify the religious belief of the Khojas? So they could have asked the Khoja experts, whoever were at the time, they could have identified, or they could have collected the Khojas and asked the general or majority opinion. And in fact, the Aga Khan's party at that time in 1866 said, yes, call all the Jamaat to court and find out. And we have already got a book with so many signatures, which shows the majority believed in the Aga Khan's practice. And 1827, the court had already said that matter of facts can only be determined by examination of witnesses or evidence that the case can bring to court. However, in 1866, the court does not use these ways of getting the opinion of what is a Khoja. They use a sectarian definition. And one of the, so this was the slide I was looking for, the reform amongst the Khojas already had created an atmosphere of rejecting caste. So the reformist Khojas themselves were not supporting this notion of we are a caste group, which all of us belong in the same. They had committed themselves to an uncompromising statement of their Sunnism. And then halfway through the course complaint or the case hearings, they say, "Oh no, we believe in Sunni practices. However, we are actually Jamaat that everyone should share equally." And then the Aga Khan's lawyer says, "No, that's not. Your beginning complaint was only about already stated their right to property on the basis of Sunnism. So if you choose to take a false foundation for your case, then you have to stand the consequences." So it's the reformist efforts and the legal logic that pushes the discussion towards a doctrinal character for the Khojas in 1866. And in the court then says not just what is the belief at present, it's also what is the belief in their origins, because you need to know the origins of the trust of when the property is held to be in trust for the community. Then when was the trust established? What was the reason for which the trust was established? That was English law of property and trusts. So they required the original covenant of the trust's creation to determine the right to that use of that property. So the court chooses a historical truth. In origins, what was the historical truth? And that kind of logic then privileges the expert academic opinion. It says, who were the Khojas in their origins? We have to find out the history. And according to the court, the history is best known by European Orientalists. So they use people like Sale's preliminary discourses to the Quran, or de Sassy's a French Orientalist, Exposé de la Religion des Drus, von Hammer's History of the Assassins, and many others. And there is in the British practice a prejudice against the modern corruption. So they felt that modern India was corrupted. There was an original pure practice that was to be trusted more. Therefore, original is true. It's not the current practice, but we must find the original practice. And the origins had to be foreign. That was another Orientalist prejudice. So Ismailism as a tradition that originated not in India, but it was a tradition that came from Iran or the Middle East. And Islam also was seen by the Orientalist as a religion of the Middle East. And Arab Islam or Persian Islam was the correct Islamic practice. And in many places in historical writings, in censuses, etc., Islam was described as an exotic religion for India. It was not an Indian religion. It was supposed to have come to India from somewhere else. Thus, original Islam had to be one that had Middle Eastern roots, and its texts and practices have to be Middle Eastern. And therefore, the Indian practice of Islam was then to be measured against this original religion. And I want to say this was not just a question of interpreting Islam. The original religion, the importance of original religion, was also used in other cases. For one case is the comparison that I make in my thesis as well with the Vaishnavas. That was a case that was tried in the Supreme Court, but in 1862, so already after the changes of caused by the rebellion. And who were the Vaishnavas? So Vaishnav was Vallabhacharya was a preacher. He established the followers of Vishnu, are Vaishnavas, and he was preaching his new religion in the 16th century. So approximately 1500s, when approximately the same time as Pir Sadruddin or Hasan Kabiruddin So it's not as if it is more ancient than the Khojas, right? They are preaching a religion at the same time, approximately. And they believed that the descendants of the preacher Vallabhacharya, the descendants, his children and his generations, they were called Maharajas. They were they held his divinity within them, and they believed that they were important in worshipping God. Various caste groups managed contributions that the devotees collected, and they supported the Maharajas in their bethaks. They were called seats of the Maharaj. And the temples were dedicated to the child god Krishna. They believed in the God's grace and love, and that this love would lead to eternal salvation. So this is just the background. The followers of the Vallabhacharya were similar middle merchant castes, the Lohanas, the Kapols, the Bhatias from Kutch and Kathiawad. So very similar background, merchant background to the Khojas. And the followers of what the case in 1862 was that the reformist followers, one of them was Karsandas Mulji, a case was fought between him and his printer and the Maharaj in Bombay. And the case was a libel case. The court had to decide in the case, I don't go into too many details, but the court had to decide whether the Maharaj was preaching adultery and sexual license. And in fact, the court ended up identifying whether the Maharajas were good Hindus based on Orientalist criteria. They used Hindu scriptures. Their criteria was, are the scriptures in Sanskrit? Are the priests Brahmins, etc., to see whether the Maharajas were actually following an original true Hinduism or not, and whether they were good Hindus or not. And Karsandas Mulji's accusation was also that the Maharajas were heterodox. They were not following an orthodox Hinduism. So the court ends up doing something quite similar to what it does in the Aga Khan case later, in that they establish what is an orthodox Shias Ismaili practice and how should the local people fit, how do they fit into this local, this classical Islamic behavior. And for the Pushti Margis or the Vallabha Vaishnavas also, they say what is the classical Hinduism and how do these local people, local practices of the Vallabhacharya sect fit into their this classical definition of Hinduism. So in the law of charitable trust was employed in the Aga Khan case, despite some of the Khojas claiming their property rights as members of the Jamaat. And the latter claim of majority members was upheld in 1851, but in 1866 we see a different legal treatment. Charitable trusts are created, we talked about that, as an original original covenant, actually. So next time we'll examine how this original faith was determined during legal argumentation and how did it match with the local practice, both mostly for the Ginans, but I will do a comparative study for how it married with how original Hinduism married with the local practice of the Vallabhacharya Vaishnavas as well. So it's not to say that Islam was treated differently by the court, even though they saw Islam as Middle Eastern. It was still the notion of a classical religion that is established in court. And they come to it in a very deliberate way, that we must think of Islam in a singular fashion, and only the correct practice can be accepted, or Hinduism in a singular way, and correct Hindu practice can be accepted. So that was one of the main impacts of the use of British law in determining disputes. So I'm saying not that the court did not want to set out to identify Islam, or in fact, throughout the cases in both the Pushtimar case and in the Vaishnav case and the Aga Khan case, they say we are not a religious court. We cannot decide what is the religion. So they are not trying to define religion, but in the course of determining rightful use of property, which is seen as a public matter, not a private matter. So religion is private, but your public rights also are based on your private identity. So religion then is reduced to a sense of identity. Then what are you identical to? What are you identifying with? And not based on how do you define yourself? How do you can't choose your faith for yourself. You have to be in tandem with a different faith that's determined by the court as the correct faith. So, I mean, we can have a discussion and I can clarify more perhaps what I want to say. But basically, the operation of British legal arguments and British legal mentality actually established this notion of classical religious Hindu or Muslim, classical singular religious identity. So with that, I'll stop. I hope I've not taken too long.
Thank you, Dr. Shodhan, for such an insightful and engaging talk. We're going to shortly begin our Q&A session. So please write all your questions in the chat box. Before I just begin the question answer session, I just wanted to talk a little bit about the wonderful way in which you detailed the whole overview of the Khojas and the colonial judicial systems and the cases in the 19th century. And I think you shed important light on an important phase of history that many of us, I think, may not have fully been aware of. And I think we have learned much more today than in the past. You've also shown that the Khoja community that came to be categorized in the colonial period was shaped by Orientalist frameworks and by legal imperatives that required communities to fit into a singular fixed definitions of religious identity. And so it was a great education for us. So thank you so much, Amita.
Thank you. My pleasure.
I will begin the Q&A. And I'm just going to go to the first question I have here. I was curious about the comparison of Khoja culture to Deccan soil. I wonder if you can elaborate on that. Justice Perry, who compared Khojas to Khoja culture to Deccan soil.
No, he compared Hinduism to Deccan soil. He said like the Deccan soil, you put anything in it, it will convert it to itself. The Hindus also, if you put anything foreign in it, will become Hindu, or it will start to look like Hindu practices. So that was his comparison. Yeah.
And why do you think the 1986 court rely on the European Orientalists instead of the Khoja experts to define the community?
1866, yeah, they did not trust the natives, so there is lots of discussion. How do we trust the natives? They don't understand the question, they don't understand the language, they don't read the original scripture, they don't know Arabic. So how will they know Islam? That was the question explicitly asked by the court. And similar for the Hindus, they said they don't know Sanskrit, so they cannot know the original religion. So we have to go to experts of people who have studied Arabic and who have analyzed the Quran or history and the documents. So it was a very particular kind of structure of who is an expert, yeah. So people who know a certain language, people who know a certain history and facts, not belief. people didn't present themselves as experts. Generally, they said we are believers, and believers were not. And they had this concept, right, that the world in India has degraded. So there was an original golden period, ancient practice was very pure and good, but because of the local, I mean, they say these things explicitly. I can give quotes for this, that it's the hot climate that creates corruption, it decays everything, and people forget their original goodness or original religion, and therefore they start to practice in a wrong way.
Mm.
So they didn't trust the current practice. And also one thing is that perhaps they all have a political opinion. So they own the property, so they want rights in it, therefore they can say anything. They'll say it according to their interest rather than the truth. So that was also that legal practitioners, even though they had Muslim officers of the court, they would say, oh, these officers are corrupt, they can be bribed, they will give the opinion according to the plaintiff, not according to the truth. So there was a lot of this kind of racial and imperial or prejudice that discounted local opinion. And it becomes more after 1857. So there was a greater use of local people before the rebellion. But after this, there is a we must control everything ourselves attitude. Yeah.
Thank you. There's another question. As regards to ownership of property, were there were there no title deeds that established who actually owned each property?
No, they had the titles. They were registered in the name of the local. For example, the Jamaat Khana in Bombay was in the name of Premji Jivraj and Dharamsi Punja in the register of properties, whereas the garden was in the name of Allah Rakha Sumar, who was the uh, Mukhi at the time. Or so different properties were in different private names, and that was one of the arguments that we don't we hold them in trust. We don't hold, these are not our personal properties, but we hold them in trust for the Jamaat, and they are created from the contributions of the Jamaat.
Thank you.
Mira, we are leading on from there.
Yeah.
Were the title to the properties then changed into the community's name, or they were left in those original people's names?
Yeah, that research I have to do. I'm not sure what the situation is after the case.
Okay. And also going back to your previous question, where you're talking about the British law kind of gradually being introduced. So before that, were the areas like panchayats and Sharia law and so on, is that what was being practiced at that time, prior to the introduction of the British law?
Yes, so the Marathas, for example, ruled Bombay, or after the Marathas, the Portuguese. In fact, the word casta is Portuguese, and it was the groups that the Portuguese established, caste groups that they recognized, not established. They recognized those groups locally, and they said, you must solve the disputes amongst yourselves. You don't come to us. So local laws, Jamaats were organized to, and sometimes the Portuguese would appoint the head of the Jamaat. And so did the Marathas. They would appoint the head. So did the Nawabs also appoint caste heads. So there's plenty of evidence from the 17th century, 18th century that the government or the Mughals or the Marathas were appointing caste heads and then authorizing them to solve disputes.
So then following from that again, when it comes to the daughter's right to any right to the property, that was very interesting. Are you basically saying at that time the girls would have no right to the property? Is that what you're saying?
Yes, that was the practice argued in the courts at the time.
Thank heavens it's changed now, right? I've got two
Yes,
daughters.
absolutely, absolutely. Yeah.
May I add something
Yeah.
to that, please?
Yes, Khurshid was trying to.
Yes, that's right. Islam Shah Saab, In fact, there are currently still many families in Delhi and many parts of India, in the Punjabi communities, where properties are not given to the girls till today. The parents have decided, okay, we'll give you jewelry, we'll give you a bronze, we've given you a trousseau and a jahez, but property will only go to the sons. So it prevails today. Maybe not amongst us, but amongst other Hindu Sikh families as well.
Yes, and even if by law the daughter can inherit, she's asked to write off, gift it to her brother.
That's right, yeah.
Yeah.
Thank you. I have a couple of other questions. One question is, what is the difference in jats and castes? And how are you using the word caste here? And how does it relate to varna in Sanatan Dharma?
Yeah. So Varna was in Dharma, in Sanatan Dharma, Varna is a very large category. Within the Varna are the many different castes. And some of these, so I'm using the word caste as a small group organization. And Nath and caste, I'm translating as the same thing. So perhaps that is a little confusing, because when you study Hindu Dharma, then they say there are 4 castes: Brahmin, Kshatriya, Vaishya, Shudra. But in the 19th, and even from the 10th century in Gujarat, actually, we have evidence that there was 84 Brahmin castes, or 84 is a ritual number that was often used, or 84, 84 caste of Vaishyas, Brahmins, everything. So caste is a smaller grouping that's regional. Many times it corresponds to the government's districts. So it was made for government to organize the marriage or taking of professions as well. Castes even ruled what money should be paid for zari. There is one case of zari workers. How much should the zari worker be paid is determined by the zari worker caste. So caste is used in that small community. It's more like a guild. Sometimes you could translate it as guild as well. So because they were combination of professional and social categories. So many of these castes were single professions, but it was never watertight. There were also new people would learn zari work if it's earning well. They would secretly learn it and practice it. So that kind of change did happen. But they were professional guilds as well. And sometimes the caste would break up. One caste, half the caste is doing one thing, half the caste is doing something else.
Yeah, and to
So
follow
I'm using the term caste as very small group. Yeah. Thanks for clarifying that. Yeah, that's important.
And so to follow up, somebody's asked, so can we say that society represents the word varna?
The big society, varna can be translated as society? No. Varna was, it was a hierarchical concept. So the whole of society was made up of 4 hierarchies of the educated, the merchants, the kshatriyas, and the agriculture craftsmen. So they were, I don't know of another term for varna besides caste in English. So there were varnas made up, yeah. Sorry, it's the society is made up of 4 varnas. So you can't translate varna as a society, but varna was a large group of similar profession castes, maybe. So it was each varna combined many different castes.
Right. And one of the last questions is when discussing religious practice of the Khojas, was the practice and beliefs of Shamsis in Punjab and northern areas practices discussed?
No, not in the case, but later and now we are more and more, we need to understand those groups to understand Ismaili practice. Yeah.
There's a question called Hindu law used to place all property in family trust with an obligation to support all family members. Is that a question? Is that a comment?
Sorry, Hindu trust. Sorry, can you please repeat that?
Hindu law used to place all property in a family trust with an obligation to support all family members.
So maybe that's a reference to the Hindu United Family. So Hindu, if it is considered joint family property, then all family members have right to maintenance. So it's a support, not a share necessarily, but maintenance. Yes. If that's the Hindu law that was also codified for India after independence, that Hindu joint family property should be not a trust. It wasn't called a trust. It was just a joint family, HUF, Hindu United Family grouping. And then if they have self-owned property, so if you have a job and you earn your salary, that did not necessarily feed into the Hindu United Family property. So yeah,
Thank you.
That's a new
Thank you so much, Dr. Shodhan. This brings us to I'm sorry, we have run out of time now. This brings us to the end of the Q&A session, and I'd appreciate if everybody can fill in the short feedback form, which I've pasted in the chat box. Thank you. And so finally, on behalf of the Association for the Study of Ginans, let me take this opportunity to say a heartfelt thank you to Dr. Shodhan, Dr. Amrita Shodhan, for such a stimulating and insightful talk. We enjoyed listening to you and are so much better informed about the evolution and the impact of colonial categories on Ismaili Khojas. Please join us for the second part on Saturday, 9th of May, 2026, which will be even more interesting, where Dr. Shodhan will examine the way in which the 1866 Aga Khan case looked at Khoja religious literature, especially Ginans, and particularly the Granth Das Avatar, and how it fit with Sunni and Shia religious beliefs as understood from Arabic Islam. A very big thank you to our IT and design expert, Altaf Bulani, for volunteering your time and expertise. Many thanks to our chairman, Shiraz Pradhan, and the board members who have helped promote this webinar. Finally, a special thank you to all the audience who are listening to us from across the world. Thank you for joining Ginan Insights. Please fill the feedback form in the chat box and visit our ASG website. And be on a lookout for our future Ginan Insight talks on Facebook and also our webinar recording on our ASG YouTube channel. You will also find past Ginan Insight recordings on YouTube. The links are all pasted in the chat box. Thank you all and have a wonderful morning, afternoon, and evening. Yali Madad.
Thank you. Yali Madad.